Alright, testing. We're connected. Alright, 1107, reserve 1108, arbitration of the certain disputes that is subject to the statutory jurisdiction of the Transportation Board, 1108, 11, definition 2, the statement of the purpose of the organization, jurisdiction 3, participation board, arbitration, and program 4, use of arbitration, 5, arbitration commencement procedures, 6, arbitrator, 7, arbitrator procedures, 8, relief, 9, decision, 10, precedent, 11, enforcement and appeals, 12, fees and costs and additional parties per side, 13, definitions are used in this part. Arbitrator mean with a single person at the point with the arbitrator of the person pursuant to these rules. The arbitrator panel with the mean with the group of the panel. The point of the arbitrator of the person pursuant to these rules. One panel of the membership would be selected with the roster for each side of the arbitrating dispute with the parties of mutual agreement. The selection of the third lead arbitrator with the strike of the methodology described in 1108 6C. Arbitration program with this program established serve the Transportation Board and step of the part with the under participating party with include with the career ship that they have agreed with the voluntary advance on a case-by-case basis with the result of the dispute between the arbitration program and eligibility man with the board using board arbitration procedures. Arbitration program and eligible man with the dispute that come out with the dispute that may be resolved with the use of board's arbitration program that include the dispute involving one or more of the following suspect with rape, the demurrage, auxiliary charge with the misrounding, mishandling the rail car, the dispute with the involved the carriers published with the rule of practice that is supplied with a particular rail transportation. Counterclaim is an independent of the arbitration claim filed with the respondent as against the complaint with arising out of the same set of the circumstances substantially related underlying the arbitration complaint, such as the board of jurisdiction final arbitration decision under reacted decision served upon by the party 30 days after the close of the arbitration evidence in the phase. Interstate commerce after the meet, the interstate commerce after the meet by the IC interstate commerce commercial intermediate commerce ICC termination act of 1995 serve the Transportation Board reauthorization 2015. The arbitrator single arbitrator the arbitrator select within the methodology outlined in 1108 6C. Monetary award cap means the award management damages up to $25 million in the rate of the dispute included the rating of the prescription of the $2 million practice dispute unless the parties mutually agree with the lower award cap. The parties bring one more counterclaim such that the counterclaims will subject to the separate monetary award cap. Practice dispute the dispute involved with the demurrage accessory charges misrouting, mishandling rail cars, disputing of the carrier of the published rule of the practice with the applied with the particular rail transportation, the statutory jurisdiction with the jurisdiction conferred with the type of transportation, interstate commerce act with include jurisdiction over the rail transportation and services that have been exempted with the regulations. Service Transportation or Board SCB means serve the Transportation Board rate of the dispute involved with the responsibleness of the carrier rates. 11082, the statement of the purpose of the organization, jurisdiction of the board, intent of the board, favored the resolution of the dispute through the meditation of the arbitrator for the proceed with the lieu of the formal board procedure whenever the possible. The second, and provide with the creative with the binding of the voluntary arbitration program in which the parties, including the ship of the railroad, agree with the advice advance the arbitrator a certain type of the dispute with a limit of the potential liability of $25 million and the rate of the dispute, including any of the rate of the disruption and the prescription of the $2 million in any other dispute unless the parties are mutually agree with the lower award cap. The board's arbitration program is open over the all parties with the eligible to bring the defendant the dispute before the board, except for the discovery. Paragraph B with the section party with the arbitrator may agree with the mutual written consent with the arbitrator of the additional major then lower amount with the potential liability with the monetary award cap identified in the section. Nothing in this rule shall be constructed in a manner to prevent the parties from independently seeking utilizing private arbitrary service if as a result of any of the disputes that may have limitation of the board arbitration program and procedures should not be available to resolve the disputes involved with the large labor protected condition to obtain grant denial state of the revocation of any license authorization construction abandonment package right, the merger right, pooling exemption limited related to such matters to describe the future of any of the conduct of the rules resolve in general with the industry-wide applicability. Resolve the dispute solely between the two or more rail cars. Parties may only use the arbitrary procedure that arbitrate with the material of the statutory jurisdiction of the board. Participation of the board arbitration program only opt-in with the procedure that any of the rail cars of the other party eligible to bring with the defendant dispute over the board may any time of the time voluntary to the output of the board arbitration program the one that may be particular with a dispute, potential dispute with before the board, until party acts over the output procedure discussed in 1108 B the output of the parties and file with the notice for the board with under the docket number to EV 699 and advising the board of the party into the participation arbitrary program such that the notice will be filed at any time should affect upon the receipt of the board. Notice the files with the board shall be the table of the arbitration program eligibility issue the party within submit with the arbitration over the submit the party discretion. Provide the lower monetary award capital of the monetary award, provide with the participation with the proceeding, whether where one of the both parties have not opted out of the arbitration program, made joint notice of the agreement to submit the dispute with the board arbitration program. The joint notice for the clearly state the issue with the parties of the will to submit the arbitrary corresponding maximum monetary award cap of the parties of the arbitrator lower amount of the monetary award cap of the will otherwise applicable to the party of the dispute. May jointly notify the board whether they agree with the submit of the eligible meet dispute with the board's arbitration program with no formal proceeding. This has begun with the board with the joint notice of the clearance state of the issue of the parties willing to submit the arbitration the corresponding maximum of the monetary award cap of the parties desire to arbitrate with the lower amount of the applicable monetary award cap the opposite proceed with the with the part of the elected with the participant in the arbitrary program of the following note of any time with the document number E69 9 informing the body board party of the decision opted for the program of the amendment of the scope of the participation. No show take of the 9 Jews the filing not selfly excuse the filing of the part of arbitration proceeding, the ongoing and permitted the withdrawal of the consent of the participant in the arbitration program eligible to dispute associated with the opt-in notice for the any of the matter board at any time period prior to the end of the 90 days before the output of the notice takes effect. Public notice the arbitration program participation. The board shall maintain the list of the participation opts with the arbitration program on the website of the transportationboard.gov with the parties of the participation arbitration only for the particular dispute will not be listed on the board's website. 1108E4 use of arbitration program eligible matters for the eligible arbitration over the board programs are rate with the determination of the accessorial charges of mishandling rail cars dispute involved with the carriers published with the rules of practices apply with a particular rail transportation. Parties may agree with the written arbitration additional matters in case-by-case basis that provide in the paragraph E of this section. Monetary reward cap of the arbitration will be subject to the arbitration program awarded $25 million, including the rated prescription per the rate dispute within $200 million per practice dispute unless defendant parties are opted within the notice of the provided lower monetary cap. The parties agree with the select with the lower award cap of the government with the arbitrary proceed with the parties made with the chain with the award cap of the incorporated the appropriate provision of the agreement in the arbitrary counterclaims will offer again for the monetary award cap, the initiating of the claim of the counterclaim of the independent claim of the subject with the monetary award of $25 million, including the rate of prescription per rate of the dispute, $2 million per practice dispute with separate with the initiating of the claim of the lower cap of the unprompted the party with the accordance with 108. 4B2. Assignment of the arbitration program matter of the board shall assign the arbitration program eligible to dispute with all the party with the receiving the participation with the board arbitration program or where one or more of the parties of the matter participating in the board arbitration program, all the other parties with the receiving the request of consent with the participation in particular dispute matter, particularly arbitration program and the eligibility issue with you with the received before the board may relate with the part of the arbitration program eligible to the material of the matters only with the part of the dispute with the relate with the arbitration program eligible matters may be arbitrated to presume the arbitration program let the parties in the position of the board in accordance with the paragraph E of this section include with the additional disputes. Other matters parties may with the position with the board with on case-to-case basis of the assignment of the arbitration dispute with the portion of the dispute with not listed for the arbitration program eligible matter with this may include with the counterclaim with the affirmative defense of the disputes that are subject with the monetary award of the cap of $2 million or two or lower cap agreed upon with the parties according to the paragraph B2 of the section. The board will not consider the arbitration type of the dispute correctly with the arbitration 11082B. Arbitration covers nothing in the board of regulation shall attempt the preempt the applicability otherwise supersede any of the new existing arbitration over the conclude with the containment of the agreement between the shipper and carriers. Rate disputes arbitrated the rate of the disputes only available to participate in the rail carrier with the time if determined by the board with the Title 49 U.S. Standard Code 10707. Rate dispute the arbitrator paying with the arbitrator with the applicable shall consider the board methodology with the setting of the maximum lawful rate given due with the conservation even the differential pricing permit the rail carrier to the colleague with the added equipment and you determined in Title 49 U.S. Standard Code 10704 A2 11085 of the arbitration commencement proceed the complaint with each of the of the paragraph of the section arbitrator with each rule commencement for the written complaint with the shall be filed with the servant in accordance with the board rules contained in the part 1104 but the chapter each complaint with the must contain of statement with the compliant with the respondent participating with the board arbitration program pursuant to 11083 with A with the complaint will be an arbitration voluntary of the part of the dispute with the pursuant of the board arbitrating procedure legal required the complaint must desire the arbitration single arbitrator instead of the three-member arbitration plan with the claim must be moved with the set of the request and complaint if the complaint is not particular with if it is not a participant is not a participant in the arbitration program the complaint must specifically issue the complaint with is willing to arbitrate with the complaint with the issue the amount of potential liability with the monetary award cap with the way complaint should specify the amount of potential liability complaint will occur. Answering the complaint to any of the must follow any of the complaint with the answer the claim with the answer of the respondent with the board arbitration program where they respond is willing to arbitrate with the particular dispute. If the complaint requests the arbitration single arbitrator instead of the arbitration point of the answer must contain a statement consenting to the arbitration single arbitrator that expresses the rejection of the request of the respondent may the request of the single arbitrator instead of the arbitration panel. The parties, if they agree with the arbitration of the single arbitrator, the board will send the case of the arbitration panel of the three arbitrators that provide 1108 6A through D. The party requesting single arbitrator the child at the time of the written notice of the board of the other party that continues the object of the third party arbitration panel upon the time they receive the notice of the board shall set the formal adjunction of the board. Well, when the complaint limits for the arbitrated issue the answer with the respondent the limitations from the board arbitration program with limitations consistent with the respondent notice fulfilled with the board pursuant to 1108.3A11. If the answer contains the agreement of the arbitration but not all of the arbitration program eligibility of the client, if the answer divide the respondent of the board and in the whether the claim will arbitrate it on the basis when the complaint process with the lower amount of the potential liability the answer for the state whether the respondent agree with the other voluntary have the counterclaim which may allow the counterclaims to give the claim with the claims they arise out of the game of the or since related or speed with the counterclaim the investment provision service contain 1108.4C through the counterclaim with the subject of the award provision contain 1108.4B23. Affirmative defense answer for the arbitration complaint will contain the specific admission for the denial of each of the file of factual allegation contained within the complaint with any information the defense of the respondent which with the air served against the complaint. Alright, jointly filed the notice. If the with a formal complaint to proceed with the arbitration of the rules of the committee for the jointly filed notice the parties agree that somebody is eligible to dispute with the board arbitration program with 1183 with the contained with the board arbitration program 203A with the relevant party with the willing to arbitrate with the voluntary may presume with the board arbitration procedure the relief requested to indicate whether the parties agree with the arbitration panel or single arbitrator with the indicate the parties agree with the lower part amount of the liability lieu of the other case applicable monetary award arbitration initiation when the parties have agreed whether they with the single arbitration panel arbitration arbitrators issue their monetary limit with the arbitration decision board shall initiate arbitration 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 agreement the arbitrators like the party arbitrator give the lead single arbitrator agree with the written agree with the minimum will save the later awarded corresponding award cap with the parties have the agreement must also contain the other mutual agreed upon and additionally the left of parties are not subsequent to these arbitration rules explain may do serve the board's actual rules board reference any arbitration when the arbitration complaint filed with the board. 1108.6 other with the arbitration 1108.5A with the agreement that all parties arbitration and the arbitrator on the job of the panel the arbitrator off the arbitration shall have the arbitrator handle the arbitration provide the hearing from the rest of the people of the arbitration regulation professional personal experience business experience including the article and private sector of the person particularly include the only race have training in the spiritual experience of the arbitrator and other forms of resolution the board established with the initial roster of the arbitrator but no objection vote the board may modify the roster at the same time objection the eligible remove the arbitrator who are no longer available to the board roster with the brief file of the arbitrator including information of the background of the arbitrating experience should go out the location of the general contact information based on the information but the truth of the roster will be uploaded on the board website. The board will update every year. The board will seek the public amendment modification that should be made. The roster include the request of the qualification of the arbitrator that should be based on the roster of the arbitrator playing roster to perform biological information on the board and crew arbitrator to wish to remain on the roster of the board of the continued availability. Selecting the lead arbitrator of the consent and mutually lead arbiter of the panel with the arbiter of the parties shall review the following process of the lead arbiter first each party give the three branches right from the nation of the roster and from the remaining of the roster of each party the last of the 10 credentials is only one arbiter of both lists he or she will select single or the arbiter both level arbiters in both the boundaries will the turn strike the listed arbiters one man's with one people is probably turn strike on the board of the entire roster and the lead of the lead shall be elected process. Are the parties conducting their own due diligence, striking the name of the arbitrator. Their selection of the lead of the arbitrator is not challengeable before the board. The lead arbitrator, appointed through the strike methodology, shall be served at the head of the arbitration panel, responsible for ensuring the S detail 1108, 709 accomplished. RD, party appointed arbitrator. The party and parties each side of the arbitrator of the dispute shall select arbitrator with the roster, regardless of whether the other party struck the arbitrator and the selecting the leader of the parties on the arbitrator with the arbitrator assists parties on the one side of the arbitration proceeding that not challenging the arbitrator selected the opposing side. Using a single arbitrator, part of this arbitration make the request to be the single arbitrator request to you, the single arbitrator must include with the complaint with the answer of the 11085A1 of the joint notice filed with 11085E. Parties of both sides of an arbitration must agree the single arbitrator options with the cannot be mutual agreement. The single arbitrator selection proceed with the outline of the paragraphs. Either the arbitrator in question during the arbitrator process is selected. The arbitrator comes in capacity unlike unwillingly unable to fulfill his or her duty to replace the arbitration properly selected with either following process. In anticipation after the appointment directly part of the arbitration with the appointment without delay with the appointment of the arbitrator to the party either set forth in 1106A, 1108 if the incapacitated arbitrator leave the single arbitrator of the party with the form of the party of the arbitrator incapacitation selection proceed with the set forth in paragraph C of this section shall apply. 1107 arbitrator proceed the initiate the exemption of the dispute of the arbitration proceed with the board shall initiate the arbitration profit the 40 days after the submission of the registration claim joint notice of the file 1108.5E the arbitration involved the rate dispute the board shall initiate arbitrating process with an intent of the board issue the decision made during the rail care with the market dominance. Arbitration after the time after the party select the single arbitrator of the panel with the three arbitrator of the lead and single arbitrator shall establish the rules of deemed necessary for the arbitration proceeding with regard to the scope of the submission evidence of the treatment of the confidential information of the particular quantity over the evidence in the jury favor shall be completed 90 days with the which the arbitration process initiated after the party court with the consent of the arbitrator panel with the arbitrators are as applicable grant with the extension of the request for written decision timetable leave the single arbitrator with the responsible writing of the arbitration decision unreacted the arbitration decision must be served the 30-day completion of the indenture phase eradicated with a copy of the arbitrator decision must be served upon the board within 60 days of the close of evidence favor of the publication of the board on the website. Extension of the arbitrator time trial table of the board may be extended with the time of the arbitration timetable provided with the power of the agreement of the all parties dispute the take forward any part of the either side of the arbitration proceed the equivalent discovery of the evidence of the conduct of the pursuant the sanitary standard protective order. Alright, 1108 relief available arbitrator will grant relief for the form of monetary damage of the rate description rate of the dispute with the able to under the power of the agreed into the writing of the parties by the rate of the prescription that should not exceed 5 years. The relief not available in injunction of the relief should be available to the board arbitrator proceeding. 11089 decision requirements whether the panel arbitrator the single arbitrator all arbitrator decisions whether shall be in writing the shall contain the line of the conclusion of all arbitrators decision must be consistent with the principle rail regulation. Again, the arbitrator shall provide the unredicated draft of the arbitration decision party of the dispute with the name of the protected order governing the fate of the confidential information pursuant to A7E. Eradicating arbitration decision single the single arbitrator shall provide the party with the draft of the decision read it recates and admit the proprietary business information pursuant any of the request of the parties under the arbitration agreement. Party input parties may then suggest if any of the additional eradication think of the required in particular against disclosure of the proprietary confidential information decision lead in single arbitrary authority and single arbitrator shall obtain the final authority if any of the additional eradications which are appropriate to make serve the arbitration decision lead in the single arbitrator serve the copy of the eradication and eradication decision part of the accordance with the timetable requirement set forth in 1187 C. The single arbitrator copy of the eradicated decision of the party of the board with the timetable requirement set forth in 1187 C. Arbitrator may the decision A with the serve the method with the permitted with the board regulation in the case of the appeal with the arbitration decision appeal with the board with leave signal the arbitrator without delay with the under seal serve the board with unreacted copy of the arbitration decision publication decision eradicated with the arbitration decision should publicly maintain the board's website. Arbitration of the decision A the binding the arbitration pursuant to receive the aim of the agree with the decision or with the arbitrator that shall be done with the and forth the aim of the court appropriate jurisdiction of the right of the appeal provided 1108 1 1108 Sorry. 1108, anytime precedent of the decision of the arbitrator, the presume the rule of the guy with the not need to bound with the agency precedent arbitration decision may have no presidential value, may not be relied upon any of the during the subsequent arbitration proceedings conducted under these rules and parts. 1108.11 enforcement and appeal. The position modified the vacate. The party may petition the board to modify the vacate of their arbitrary award. The appeal must be filed within 20 days with the board of the final arbitration decision and the subject for the page limitation 11.15 D of the chapter. The copies of the appeal shall be served with the unpart according to the board's the rules of the part 1104 of the chapter of the repealing part of the serve the copy of the appeal upon the arbitrator of the replay shall be filed within 20 days of the filing of the appeal of the board that shall be subject to the page limitation 11.11.15. Sorry, 11.15.2 of D with subchapter the board. Reviews on appeal of the board stand for the review of the arbitration decision will narrow the board will review the decision of the determine if the decision consistent with the sound principle of rail regulation, economic with a clear abuse of arbitrational authority, the discretion occur with the decision directly controversial transparency, statutory authority, awarding limitation violated, even the standard of the board modified with the vacate of the arbitration award, then holding in part. Board of the vacating of the modification arbitration decision of the board stand the review available to the Hobbs Act Title 28 U.S. Code 2321 2342. Nothing in these rules shall be prevented the arbitration seek with the judicial review arbitration award with the court appropriate jurisdiction pursuit under the Federal Arbitration Act of 19 U.S. Code 9 through 13 in lieu of the seeking board review. Staying arbitration decision timely filing with the petition review of the arbitrational decision board will not automatically stay in effect with the arbitration decision statement. The record 11 and 15 with 3 with the chapter enforcement parties seek with the enforce the arbitration decision pursuant to the board's arbitration program must petition the court with the appropriate jurisdiction of the Federal Arbitration Act of Title 4 9 U.S. Code 9 through 13. Or 1108.12 fees and costs filing fee with the review of the board arbitration proceed with the result of the party filing with the complaint with the answering with the pay the filing of the 1149 and for Title 1002. Call the party should share with the cost incurred with the board with the arbitrator equally with each of the party responsible paying with its own legal and other associated arbitration costs. 1108.13 additional parties person the arbitration complaint with the file with more than one complaint with particular arbitration proceeding against it is an answer to the counterclaim with the more than one respond by the arbitration rule will apply with the compliance as a group and the response group in the same manner as will apply with the individual opposing parties. Alright, and that was part. Moving on to the next rule will be the 1109 using meditation in the board proceedings. And then we'll go back to this one. This was part 1108, arbitration and certain disputes subject to the jurisdiction of the transportation board.